Ready for the dictation at the speed of 90 words per minute. Start. By the present petition under section 482 of the Code of Criminal Procedure, the petitioner has challenged the order dated 24/11/2022 passed by learned additional district magistrate within bracket city Bikaner in criminal case number 12/2022, whereby the learned magistrate has ordered to drop the proceedings without disposing of the case on merit. Stop. The said order has been passed in pursuant to the order dated 23/11/2022 passed by the Revisional Court, that is Additional Sessions Court. Stop. Brief facts of the case are that the petitioner complainant filed a complaint in the Court of Additional District Magistrate Bikaner alleging inter alia that her parental house is located as mentioned in the complaint, lease of which was issued in favor of her great-grandfather. Stop. Electricity and water connection of the house is in the name of his grandfather. Stop. The informant assured her to take the said articles to his village within next 5 to 7 days. Stop. Para. Thereafter, non-applicant submitted an application before the learned trial magistrate requesting to hand over the possession of the disputed property in pursuant of the order of Revisional Court, on which the learned magistrate passed the impugn order dated 24/11/2022, and while releasing the disputed property from the attachment, ordered to drop the proceedings without disposing of the case on merit. Stop. It is this order that has been challenged by the petitioner in the present petition under section 482 of the Criminal Procedure Code. Stop. I have considered the rival contentions raised by both the parties and perused the record as well as the impugn order. Stop. The main attack made by the learned counsel for the petitioner is that learned magistrate has committed a grave error of law while misinterpreting the order dated 23/11/2022, while dropping off entire the proceedings, which is not sustainable in the eye of law, that learned Revisional Court had nowhere issued directions with regard to the drop the entire proceedings. Therefore, the reliance placed by the learned magistrate is nothing but sheer misuse of process of law. Stop. Dropping the entire proceedings against the respondents was not only illegal but beyond the jurisdiction also, that the learned magistrate has failed to understand the true spirit and intention of the legislature. Stop. Para. It is further argued that it was mandatory on part of the learned single judge to record the evidence and decide the complaint upon merit as per law. However, while adversely affecting the rights of the petitioner and without deciding the original complaint on merit, the entire proceedings has been dropped in the garb of order of revisional court which was absolutely illegal. Stop. It is further argued that the order passed by the revisional court cannot ipso facto be treated as dropping all the proceedings by the learned magistrate. Stop. Whereas learned counsel for the respondents supported the impugn order and submitted that there is no illegality in the order passed, therefore, it is not required to be interfered with. Stop. Therefore, it is prayed that learned trial court be directed to decide the application preferred by the petitioner upon merit. Stop.